One, two, one, 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 two.
Dia benar.
One, two, one, 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 two.
Yeah.
One, two, one.
One, two, one, two, one, two, one, two. One, two, one, two. Number two, your witness. One, two, one, two, one, two, one, two. Checker three. One, two, one, two, one, two, one, two. One, two. One, two, one, two, one, two, one, two. One, two, one, two, one, two, one, two, one, two. One, two. One, two, one, two, one, two, one, two, one, two. One. One, two, one, two, one, two, one, two, one, two, one, two. Okay. One, two, one, two, one, two, one, two.
One, two, one, 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 two. One, two.
One. Good morning, all. It's 29 minutes past 9. We are ready to start the day's proceedings. Please make sure that your cell phones are on silent or they are off. Thank you.
Good morning, Mr. Ramatsekisa. Good morning, Ms. Powe. And good morning, Mr. Sisoko.
Good morning, Commissioner.
Thank you.
Good morning, Chair, Commissioners. The witness this morning is Matthew Sisoko, and the witness is ready to be sworn in.
Thank you. Is Matthew Sisoko, are those your full names, or do you want to state your full names?
That is correct, Chair. My name is Matthew Sisoko.
Thank you. Do you swear that you are going to swear or affirm, or which one?
I will swear.
Do you swear that the evidence you are going to give is the truth, the whole truth, nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you.
Thank you, Chair. Chair, this morning, you will, just one housekeeping issue. Yesterday, the commissioners were furnished with the statement and annexures of the witness. At that time, the witness was still commissioning the affidavit, but because we wanted to make sure that the commissioners are furnished with the statement, we did make it available unsigned. Later in the evening, we received the signed version, and there is no difference but for in paragraph 26 of the statement, and that relates to a date. I'm doing this in case you made notes in the old one. So the only difference is if you go to page 12.
Of the one we were given yesterday, 12 of the one given to us yesterday,
It would be
paragraph,
paragraph 26. So it will page 11.
yes.
Paragraph 26. So the old one, the last sentence, the second last sentence, reads, the Operations Manual version 2.0 was signed by me as Head of Investigations and Operations and by the ID on 16 October 2024, and it was shared with every employee at IDEC. It is in substance and in the manner of its adoption a policy of the unit. The new one inserts the date on which it was shared with all of the employees. And so it says, and it was shared with every employee of IDEC on the 22nd of October 2024 at 11:31. So that's the inclusion. Oh, so they didn't make notes of it.
Just a minute, then, please. Yes, we are ready. Thank
All right,
you.
thank you. And so whether or not you look at the signed or unsigned, that is really the difference between the two. For this morning, Chair, I can't guarantee for about this afternoon, but certainly this morning we'll be using one file, and that's the statement file with the, they have two files? Oh, I have one file, but I'm advised you have two files,
Yes,
one
yes.
containing the statement and the other containing the annexures.
Yes.
Mr. Sissoko, you also would have two files in front of you, one containing your statement and the other containing your annexures. Can we then go on to just confirm your statement? If you look at the statement file, the first document should be your statement. Can you confirm that this is a statement that you have prepared for purposes of giving your testimony before the commission?
That is correct.
And if you can go to page 25, is that your signature?
That is correct.
And do you confirm that the contents of the statement are true and correct to the best of your knowledge?
That is correct.
All right, thank you. Chair, Commissioners, I've discussed it with the witness, and I have informed the witness that we have read the statement, and so our approach to the statement this morning will be to highlight certain aspects, and then we will focus in on the parts of the operations manual and then his involvement in the cases that the Commission is looking into. Mr. Sissoko, if we can then start at page 2 of your statement where you deal with your background and experience. Can you summarize for us your background and experience with particular reference to paragraph 4 of your statement?
Just state only the salient features of your background, your qualifications, and your experience. Just the salient features, because I see this is quite a lengthy one.
Will do so, Chair.
We have read everything.
I'll do so, Chair. Basically, my career in the criminal justice system started as a prosecutor.
Sorry, maybe before you go there, your current position at IDEC and then move to the
All right.
other.
All right. My current position at IDEC is the National Head of Investigation and Operations. I assumed that position in October of 2021 as a seconded employee from IPID and then formally transferred to the NPA in 2022 December. Before then, I was the head of investigations at IPID, and then I had an illustrious career within IPID and its predecessor, ICD, from 1997 until 2021.
And
And
ICD,
before then,
my apologies, and ICD is?
the ICD is the predecessor to IPID.
Yes, it's the Independent Complaints Directorate.
Independent Complaints Directorate.
Thank you. And prior to that?
And prior to that, I was a prosecutor within the Department of Justice from 1993 to 1997.
Thank you. You then say in your statement, after you deal with the various trainings you've attended, that there are two features of your background that will be relevant to what we will be discussing. At paragraph 7 of your statement, can you deal with those two aspects?
Thanks, Chair. First, I'm the former head of investigation at IPID.
Sorry, so why is the statement? Oh, there it is, okay. Thank you. No, I wanted to ask why it's not being flighted. I see it's on screen now.
All right. And together with the former IPID Executive Director, Mr. McBride, I testified before the Zondo Commission about police corruption. When the ID was established, investigation relating to police corruption arising from that testimony were authorized and moved into ID, which is now IDEC, together with certain investigators who worked on those matters. That is how investigators such as Mr. Mansara Peso, Mr. Timani Binang, Mr. Anthony Sihas, and Mr. Stanton Govender came into the IDEC. On the 20th of July 2026, I forwarded to the ID documents that I was able to source relating to discussions between the former ID and the acting executive director of IPID relating to the process of case handover to ID and secondment of IPID investigators in IDEC, then ID. The documents are attached and marked MS01. The bundle of document is a memo from the former ID, Advocate Cronje, and has annexures A to H. Annexure G of the attached document is a list of cases that were requested from IPID. Chair, I put this in the statement because the Commission asked me to deal with this issue, but also importantly that Advocate Johnson testified about it, that he had asked me to get this information, assist her to get the information from IPID. And this is the information I got.
Mr. Soko, just out of interest, good morning. Are you an attorney or an advocate?
No, I'm not either.
So you were a prosecutor
Yes.
and then rose through the ranks
Yes.
as a prosecutor?
Yes, so I moved from prosecution side and went to investigation side.
So in your role at IDEC, you cannot prosecute?
No.
Thank you.
Secondly, my own history at IPID informs the approach I took to the matters described below, as I explained under the heading why I did not insert myself into these matters.
Thank you. Chair, you recall that during Advocate Johnson's testimony, the Commission wanted to know which cases were transferred from IPID to IDEC, and that's contained at page 47 of the bundle of documents that is included as annexure MS01. It then also includes requests for deviations for members, some of the members to be transferred. And those are the documents that follow Annexure G. You don't have to. Okay. The second aspect of your statement that I'd like us to turn to is in the mandate of IDEC. Now, a number of witnesses have explained the mandate of IDEC. So if you can, at a snapshot, what exactly is the mandate of IDEC? You don't need to explain at length.
So, Chair, there should be complexity to these matters, because otherwise you've got other law enforcement agencies like DPCI that deals with similar corruption matters. So at IDEC, we then concentrate more on the complex, high-profile ones and those commercial ones that are high-value matters.
Okay, thank you. And then we can then move to the operations or the operations model of IDEC. And you deal there with it at paragraph 10 of your statement. And I think the DDPP advocate Sirunye dealt with in some detail on the principle of prosecution-led investigations and what their roles are. But can you, in summary, deal with, at its core, how do you operate within IDEC?
So, how we operate at IDEC, Chair? The prosecution-led investigation presupposes that it is a multidisciplinary team that is led by the DDPP. It will have a lead prosecutor, a lead investigator, a lead criminal investigator, a lead financial investigator. Then there will be also other lower-ranking investigators and lower-ranking financial investigators. You'll also have a data analyst as part of the team. In practice, the DDPP will be the one that would normally submit an authorization for investigation to the ID and even propose the team that is to be designated into that investigation to be part of that investigation. Once the ID approves that authorization, then the project manager who is designated to that project will then convene a team meeting of everyone who is part of that team. Then they will start to plan for that project in terms of the investigation and prosecution strategy, and they will then develop a project plan for that investigation. Then there will be taskings that will be issued to the different functionaries who will then execute the taskings as per the project plan.
So in essence, you say that the DDPPs lead a multidisciplinary team, which consists of the various functionaries that you mentioned. Now, you then say at paragraph 11 that in terms of how the flow of information or how reporting happens, is that then these DDPPs report, one, to the ID, and then in another sense, there are then these operational management committees, which you would be the chair of, where they report.
That is correct. So the DDPPs report directly to the ID. The operational management meeting, which we call OMC, it's for the management to monitor progress on these investigations as well as the prosecution thereof, and to see that matters progress as per the project plans. And where there are issues that need to be addressed, then there are recommendations made in terms of how this should be addressed.
You mentioned the OMC in the past tense. You say you used to chair it. Why the past tense?
Yes, Chair, I used to chair it. what happened is that when I came back to work after my unfortunate incident of kidnapping, I found that it had changed. A decision was made that the DDPPs would now chair that committee.
Would they rotate because there's what, 4 of them or
Yes, yes, they would rotate.
not? All right.
When did you come back to work for this, to find this new arrangement?
I think it was the 13th of January, 2026.
And was an explanation given for that?
No, there wasn't.
Thank you.
Advocate Serunye described the relationship between the DDPPs and your office as a dotted line of reporting. Would this new arrangement then change that, or is there any reporting anymore that's done to you?
Chair,
Or your office, sorry.
Chair, there isn't a dotted line of reporting. The DDPPs do not report to me, they report to the ID. What happens is because I'm involved with operations, hence I was chairing that OMC, was just to oversee that all the projects are executed in line with the plans. So in practice, what would happen is that the project managers would then report if there are any issues in the projects, and then they would report to me. I would make interventions to unlock whatever issues that would have been raised with me. And if they needed escalation to the ID, then I would escalate those to the ID. And what would normally happen also is that when the teams are satisfied that investigations are complete and they are ready to enroll a matter, then a meeting would be called. Some colleagues call it the panel, as I had Advocate Serunye testify. A meeting will be called where myself and the ID and the DDPP responsible for that matter will get presentation from the lead prosecutors about that matter and to assess if their decision to enroll is something that it's valid and based on the factual basis based on their presentation. And then once we are of the view that it's ready to be enrolled, then the ID will give the stamp of approval, and then it will then be enrolled, and other processes will follow in terms of the takedown and so forth.
Just to be sure, do I understand you to mean, except for being divested of your power to chair the OMC, your powers remain the same, or not?
Yeah, the powers remain the same.
Thank you, thank you.
And
This process that you describe, where you, the ID, and I think you said the DDPP would constitute a panel where a presentation is made and a decision is made eventually a decision is made whether matters are ready for enrollment for a final decision by the ID. Did that continue to be the position until last week while Advocate Johnson was still there? Or are you describing historically that's how it used to be, or are you saying that has continued to be the case even after you were removed?
Historically, Chair and Commissioners, that's how it used to be.
Okay.
In recent past, it was no longer like that. But in most of the matters that we dealt with and were able to enroll, that is how it used to happen.
Thank you.
In your description of what is reported at OMCs, I got the sense that it was operational matters that were reported. You are both the head of operations and investigations. So at that level, do you also give input on what's happening on the investigative side of things?
That is correct.
So you deal with things like capacity issues. Would it extend to the approaches in the various matters?
As it relates to investigation, yes. When it comes to prosecution, it's only the prosecutors that would deal with that issue. But when it relates to investigation, would make our inputs in relation to that.
Please clarify this. Do the investigators, that is Mr. Belushan, Mr. Padiaki, and all those people, do they report to you as head of investigations? How does it work? Who do they report to?
Only Mr. Dylan Perumal and Chief Boy reported to me as chiefs.
Perumal and who?
Boy.
Boy.
Chief Boy, yes. Nico Boy. So how the structure used to look like, all personnel who are under investigation will fall under my command, to use that word. So the chiefs will report to me, and then those that fall under them will report to them. For instance, the senior investigators will report to the chiefs, and then the investigators will report to senior investigators or directly to the chiefs, depending on a matter.
And then the prosecutors, who would they report to?
The prosecutors will primarily report to the DDPPs.
And then the DDPPs
in
would
the
report
different
to
levels.
Advocate Johnson.
And then the DDPPs will report to Advocate Johnson.
Yes. So you were Mr. Perumal's boss?
Yes, I was.
When did that change?
So what happened is that after I came back, I found that apparently there was a strategic plan that was convened that came with changes to the extent that even the reporting lines were changed. So Chief Boy, Chief Perumal signed their performance agreement with Advocate Johnson, and not with me, as it were previously.
So since that plan, they have been reporting directly to the ID, Advocate Johnson?
Yes, with their new performance agreement. Even though administratively I would sign off on their, which is the letter that the ID issued with me after I raised the issue with her, and then she issued me a delegation letter, basically to deal with administrative issues relating to their work, like leave, travel, and so forth.
So you were divested of more than just the power to chair the MOC. Remember, I asked you whether the only power you were divested of was chairing the OMC, and you said yes. So
that's my mistake, Chair.
Yeah.
I didn't think about this one at the time. Yes.
Yeah. No, thank you. No problem.
Sorry, just lastly. How long were you away from work? You say you came back in January 2026, having been away since when?
The incident happened on the 6th or 7th of November. So I was away from work from then until
For about 2 months.
about 2 months, yes.
Thank you.
So just to be clear, prior to this, the roundabout, I think you said in your statement, the 8th of November, Chief Peramore and Chief Boy reported to you.
Yes, they did.
Okay, thank you. And then at paragraph 12, we deal with that, the teams don't share the details of each team's matters. And that has been explained. But one thing that I was particularly interested in is what you say about reporting of the ID's matters at OMC. Can you explain what you say there in paragraph 12?
So, Chair, there were matters that would come directly to the ID's office. And colloquially in the office, they would call them ID matters. Because the ID would have taken decision on those matters. And in the OMC, they wouldn't be discussed. All other matters will be discussed except for those, because of it was indicated there were sensitive matters. So the CI matters would be one of those where there wasn't discussion really about them, except in those teams where they were dealing with them.
Outside of the CI matters, what other matters existed that were deemed ID matters?
I think one matter that I can think of is the speaker matter. There's also Project Golden.
My apologies, Project?
Project Golden.
Golden. Okay.
Yes. So those were the matters that were authorized from ID's office. But my understanding is that those matters, even though they were authorized from ID's office, for instance, the speaker matter, she did call a meeting. I was part of that meeting, and the assessment of that matter was done with us and the prosecutors. The Project Golden, I wasn't part of that assessment, but I'm informed that the DDPP responsible for that matter did the assessment with the prosecutors, and that's how those matters were authorized.
Just to be clear, if the speaker matter, as I understand it, and you've confirmed it now, you were involved in that authorization process?
Yes, so the ID called a meeting to say she received this matter, and that invited also the prosecutors that they must assess it and then advise her, and then she was in fact advised. We did have a conversation about it, and then I think there was a general consensus that it falls within our mandate, but the prosecutors went further to do further assessment and then advised her that it does fall within our mandate and it should be authorized. And an authorization submission was prepared for her.
So although it came in through her office, it ran through the ordinary process
Yes.
of an evaluation
Yes.
and recommendation for her to authorize and proper
Yes.
authorization.
Yes.
Now, with the Golden matter, you say that similarly there, although you weren't involved, a DDP was involved
Yes.
in the processes.
Yes, and other prosecutors.
So the only one that is truly different would be the CI matters, because we know from testimony before this commission that it didn't go through any of that process.
That's correct.
Just ask the Project Golden, you were not part of it because you were excluded or you were not available. I'm just trying to understand why you would have been involved with the speaker matter or referral, and then you don't get involved with Project Golden.
Chair, to be honest, I sometimes the decisions that the ID would take, I wouldn't really understand. Sometimes she would say to me, so I forgot to inform you, and then inform me of a matter after the fact that she had taken this decision, you know. So I think it's the same also with Project Golden. From what I understood, she called the deputy, discussed the matter with the deputy, with the prosecutors, and then they then did the assessment and prepared submissions to her for authorization.
So is it one of those that she said, I forgot to include? I'm just trying to understand, you were at work in that period, I assume.
Yes.
You don't become involved, is it because, does she then subsequently say, I forgot? Or she says nothing, the project just continues to run and you're not involved with it?
Yeah, I only got to know about it when I was discussing with the project managers. Then I found out that there is this authorization on Project Golden. When I inquired further with the deputy, then the deputy explained to me. The deputy explained to me how it came about. From what I understand, it's a SARS referral to IDEC. So that's how I got to know about it.
You know,
So
Mr.
I must also indicate, Chair, so that there's a complete picture for the Commission. There was a point, I just can't remember exactly when, it might have been 2 years or so earlier, where she called me into a meeting with the management of SARS, and there was a discussion about the same issue, but it was much bigger, from what I understand. But the conclusion of that meeting was that because the matter is already with DPCI, and because of how huge the investigation is, we didn't have enough resources to deal with it. And it was agreed that it will be left with DPCI. So I only learned, it must have been a year later or so, that now it's been authorized. But it's only some part of that, not the entire investigation.
I have to ask, and I ask because we now know a lot happened, a lot of wrong happened in the way things were done in IDEC. So I have to ask again the direct question. Is this one of the matters where she said to you, I forgot to tell you?
Chair, we never spoke about it. She never said anything to me about it. I'm just saying that sometimes, or from time to time, there will be decisions taken where she would then, when I'm in a meeting with her, and she say, hey, Sisoko, I'm sorry. This is what happened. I took this decision. I forgot to inform you, but not specifically on this matter.
Thank you.
And then just
Sorry, can you just give us a picture of how your offices, hers and yours, are positioned or located within your building? Are you here and then there are several offices in between and she's that side, or are your offices next to each other? Just give us an idea.
They are not next to each other, but they are not far from each other. We are on the same floor.
Okay.
So She's slightly on the other end, I'm on the other end.
Okay.
You know,
I just wanted to.
it's a long passage.
Yes.
Her office is in the middle of the passage, and then my office is on the other end of the passage.
Okay. I just wanted to understand the forgetting. Yeah. For example, if you are right next door to each other, I just would not understand the forgetting whatsoever. Not that I understand it now, not at all. Anyway, let's continue.
Can I just
Sorry, can I just ask still on this, Mr. Soko? The impression that I had gained was that through your intake processes that are set out in your manual, that process would result in a record or a tally, if you like, of matters that are coming in. And you tell us your process, that it comes in terms of the manual, and there would be evaluations, some would be taken on, some would not be taken on, and there's a process if matters are not taken on. So I would expect that somewhere you have a record of matters that have been referred, and I would expect they would include matters that become the IDs matters. And I would have thought by virtue of your position, I assumed by virtue of your position, you would have a repository of that. If we asked you what matters have been taken on by ID, you would be able to print it off, because it's matter that as investigating director or head, you would have access to that. What does it mean then for matters such as this, where there's a Project Golden, you know nothing about it, it's the ID's matter, she has spoken to the DDPP and investigations run. When it comes to your records of you knowing what your organization is dealing with, what does it mean for matters like that? In practice, what is the consequence?
So in practice, Chair and Commissioners, when a matter is authorized, it goes to the project managers. The project managers are responsible for that project. Then they would assign it a case intake number, and then it will be put on a register, a case intake register, which have all the matters that are within IDEC. So we created that register, especially when I came in. It was there, but it was not fully developed, and then I insisted that the register becomes fully developed and be able to cater for all the different scenarios that might be needed for information purposes and also for performance information purposes. So that register will have all these matters. So how I get to know, for instance, is when I see in the register does not have full details of the matter, except like in that case, it will say CIN number so and so, and then it's maybe we give it, each project has a name, so it will be Project Golden, for instance, in this case. So when I have a meeting with project managers, then I ask what this matter is about, because I wasn't aware of it. Then they would explain, no, this is what it's about, and I would engage the deputy concerned about it. The thing is, that is how we've been operating. And when I came back from leave, I find that also that register is no longer made available to everyone, as it were. And hence later I talked to a matter that I became aware of, which was authorized in my absence, which I found also concerning.
Thank you.
That's very helpful. It gives meaning to CIN. I've seen CIN a number of times, and I didn't think it actually stands for something.
Case intake number. CIN stands for case intake number.
Thank you very much. Thank you.
Mr. Sisoko, what I wanted to know, just one more aspect in relation to the 3 cases that were sort of deemed ID matters. The first one, Speaker, if I'm not mistaken, was in 2023.
Yes, I think it
Correct.
was.
Now, when you sit at OM, and this ran through the processes we know, and you were involved in the process, when you then sit at OMC and you no longer get reports about this, was this then raised with the ID?
We had a discussion about these matters, and her view has always been that these are sensitive matters that, must remain like that. However, when a matter has been enrolled, then we then talk about its processes, even at OMC, whether it's postponed for trial or whatever the case may be. But at the stage when there is still investigation on it, they weren't discussed.
There was resistance, you say?
They weren't discussed at the OMC.
They weren't discussed. Okay, thank you.
I just understand how it is explained. I accept that when people are working, that you have a system where one team that's working in the matter, they will keep it within the team. And it's easy to think about a need-to-know principle, that, well, people don't need to know, and that's how you manage information. But the idea that matters are sensitive, therefore, they will not be discussed with you, for example. When you hold a particular position, you're head of investigations, you have taken oath, you are bound to the same principles or the same rules as your ID for confidentiality, and if you disclose, you've broken the law. It applies equally to her. How does it get explained, and how do you reconcile with, well, you can't know certain things. A DPP, another DDPP will know, but you can't know, as if you're not subject to the same rules. Can you just explain to us how it is explained in the office and how that is reconcilable with the position you hold?
Commissioners, some of those sensitive matters, as it were, like I indicated, like your speaker matter, they were discussed with me. The explanation about sensitivity stems from the fact that they are matters that sort of the ID owns. They come from her office. She decided on their authorization, and then she decides also who, as opposed to other matters, who is designated in those matters. So, for instance, other matters, as I indicated, it will be the deputies that decides the designations of members who will be part of that team. However, in those matters, the ID herself will decide who she wants to be in those matters. So that is how it worked. And I would, from time to time, get complaints, for instance, from even deputies that you find there are resources in their projects who have been roped in to the ID matters, and they would want them to task them on other matters, and an investigator, for instance, will say, no, I'm busy with an ID matter, and there would be those kind of issues that I have now to deal with, to say, how do I then assist with resources so that the other projects do not suffer, because some resources are put on those matters.
And by that, sorry, and by that you mean they will be taken out of their teams? Because
Yes.
as I understand it,
Yes.
they all belong to those 4 teams. So they would be taken out of those teams and plonked elsewhere altogether.
Yes, on these projects.
Maybe lastly, so it sounds from your explanation, including the answer to the chair, that there was no, or there was no objective criteria. You've told us about the intake process and what criteria and the scoring that you do about matters that eventually get taken or rejected. The ID matters, as you call them, there was no objective organizational criteria. It was entirely up to the ID. She gets a matter and she decides, however she gets it. If it came to her directly, she decides whether this gets treated like the speaker matter or gets treated like your Project Golden matter, where it's entirely up to her to make the decision.
Yes, that is correct, Commissioner. And that's why I'm saying not all, in fact, almost all matters were dealt with in line with, what I previously said about, being assessed and so forth, either by me or by my other colleagues, the deputies. But those that she made decisions on, that's where there was that a difference, because the approach would be different as compared to other matters.
Thank you. Thanks, Ms. Bond.
And just one more question on this. At a stage where it's clear now, I mean, you are now implementing this process where ID matters are not discussed, at a stage that you can't do your job because there are complaints coming in about resources, there are investigations you know nothing about. Do you again raise this as an impediment to your job and your ability to function?
Chair, we would always find ways, because what we always understood is that when they came from the ID's office, those are priority matters. So we'll always find ways to make sure that these other projects, still continue with whatever, resources we have, move people around so that they can assist. So for instance, if there is a particular tasking in another matter, and then the resource working on another matter is being used in the ID project, then we would find another resource somewhere to deal with whatever tasking that needs to be done on this other matter. So we'll always find ways to ameliorate that challenge.
Okay. Now, you've described in detail the intake process, and we've heard testimony from other witnesses about how it works and how it ordinarily unfolded. Unless the commissioners want you to go into detail, my proposal would be, because I think what's different is your explanation of why this multi-level intake process was important. So could you deal with that, unless, commissioners, there's a question around what was set out in the ops manual about how the intake process ordinarily works?
Shouldn't Mrs. Soko perhaps start reading from paragraph 16, or not?
Chair, my proposal was that we don't...
We skip even
it,
that. So where do we start?
To deal with why the multi-level intake process matters.
Which is about which
At
paragraph?
At paragraph 23.
Oh,
Yes.
I did not hear that. Yeah, let's do that.
Yeah. Just for the record, in some, the paragraphs before deal with how matters reach IDEC, the registration process, verification and screening, the intake assessment and the scoring process, the authorization of investigations, the planning and conducting and finalization of investigations, and thereafter securing attendance and prosecution, and ultimately the closure of matters. What's different about your statement is you deal with why this process is important. Can we then go to paragraph 23 of your statement?
Thanks, Chair. Maybe before I deal with that quickly, so I don't want the Commission to be left with a wrong impression. The manual was approved, as I've indicated, and other colleagues have also stated that. It was shared with all the colleagues in IDEC, and when new people come, you know, those responsible DPPs will always workshop it to them. The fact of the matter is the intake process did not operate to the T as provided for in the manual. So that is what the reality was, as you know, my previous explanation had explained about how some of the matters came in. But even though it was not to the T, but most matters would go through that assessment process. And later in my affidavit will show that, in fact, most of the matters that we did in IDEC are matters that came from the commissions, which came in as a result of the presidential proclamation, and therefore did not go through this process, but rather as a result of the presidential proclamation, and the former ID would have authorized them because of that presidential proclamation, and wrote to law enforcement agencies like IPID and DPCI and requested all those matters to come to the ID then for them to be investigated. So I just wanted to clarify that.
Thank you. Advocate Johnson said, for example, about Mr. Adams's referral. She said she did not discuss that with you because it was a simple matter, and she was of the view that she could handle it all by herself without involving you. Are you aware of any instances, or rather, how should I put it? Are you aware that the fact that a matter was simple, whatever that means, that was a factor or a criterion that could be used not to involve other people at the initial stages of a matter or of an intake?
I'm not aware of any except for that specific matter.
And that's not an issue that was ever discussed within IDEC?
No.
So she never said, with simple matters, I will not bother you, Mr. Sissoko?
No. The decision to authorize that matter was not discussed with me, commissioners. As I will continue my testimony, you'll understand.
All right.
What happened.
No, I just wanted to understand the criterion she said she used in respect of this crime intelligence, these crime intelligence matters.
I would have asked the same question in a different way, so I'm covered by the chair. Thank you.
And then just on the application of the manual, so to the extent that Advocate Johnson testified that the manual was just a draft, she would have been misleading this commission. Well, at its lightest, she would have lied to this commission.
Yeah, I don't understand why she said that. The manual was signed by myself and her, and then at her instruction, it was distributed to all IDEC staff.
Just remind us for purposes of the record, we've seen it, but for the record, when did she and you sign it?
I have a date somewhere. I can't remember the paragraph now. But I do indicate that in my affidavit. I think it was October 2024, if I'm not mistaken.
Chair, it is at file 10.
Paragraph, but in the affidavit, it's paragraph 26, top of foot of
Yes,
page,
yes,
foot of page 11,
paragraph 26.
top of page 12.
Yes, yes.
But Ms. Bowe wants to take us to the document itself.
At page 10 of page 10 of file 10. To the signatures.
Okay, let's,
Yeah.
so it was not a draft, it was signed.
Yes.
Even distributed to.
Yes.
Yeah.
And I do indicate that it was distributed on the, what we call ID comms,
Yes.
where it include all staff, on the 22nd
All right.
of October,
Thank you.
2024.
Thank you.
Did it differ much from version 1?
Sorry,
Just look at your screen. Do you see that there's amendment history, the heading, and version 1
yes,
was signed on 18 December 2023, and then the current version 16 October 2024. So did the current version differ much from version 1?
so Commissioner's version 1 was never signed.
Was never signed.
It was a discussion document. As you'll see from my affidavit, I indicated that it was a consultative process. So we had consultants that were assisting us with this document, and then they would send a draft. So the version 1 is the draft that was first sent. We had to engage with it and then make changes on it. And when everyone was satisfied that the version 2 it's the product of what we agreed on, then that's when it was signed off.
And the way things work at IDEC, you know, in other organizations, a document gets signed and then it will have an effective date. And sometimes the effective date will be sometime in the future. Mm-hmm. So with this manual, what was the effective date? Did it take effect from the moment the two of you signed and authorized it?
Yes.
Thank you. Mr. Soga, then if you can then go to why the multi-level intake process matters.
Yes. So I emphasize the intake and case selection process, case selection stage of the process, because it is deliberately multi-layered and collective. Its stated objective is that case selection is transparent, objective, auditable, and defensible, and that it cannot be manipulated. There is, however, a further and equally important object: to insulate the ID from any allegation that IDEC is targeting particular persons or picking or declining cases without proper basis. If a matter is received, assessed, and scored and recommended by a team and a committee before it reaches the ID for authorization, the ID decision rests on a documented defensible foundation, and the ID is protected against the very allegations that are now being made. I was closely involved in creating this framework. I drafted the case intake process that became a case selection criteria, Annexure A to the manual. in August 2022, and I'm a signatory to it. The purpose of that process, as recorded in the document itself, was to establish a case intake and selection process that is impervious to undue external influence and that ensures IDEC is not manipulated to select cases furthering a personal or political agenda. It provided for case intake to assess matters and advise the ID. In 2024, IDEC embarked on an inclusive process involving members across the department to produce the operational manual, which sets out processes in detail and incorporates the intake criteria. The operational manual version 2 was signed by me as head of investigation and operation and by the ID on the 16th of October 2024, and it was shared with every staff of IDEC on the 22nd of October 2024 at 11:31. It is, in substance and in the manner of its adoption, a policy of the unit. The framework contemplated a single designated intake point together with the case intake committee. It motivated for a dedicated post to fulfill this function.
I think you say here I, not it. So I motivated.
Oh, sorry, I motivated for a dedicated post to fulfill this function. A person who would receive all incoming complaints, conduct the first assessment of whether the matter falls within the mandate, refer qualifying matters to the case intake committee, and act as its secretary to that committee. The object, again, was to ensure that the ID does not take intake decisions alone, and that she is insulated from allegations of targeting a particular person or having an interest in particular investigation. The job description for that post records these functions expressly, including that the incumbent is to receive and register all incoming cases, evaluate whether they are within mandate, refer out-of-mandate matters, convene the case intake committee, and act as its secretariat. See the attached job description marked MS1. I initially designated the post investigating coordinator. Through the organizational development and job evaluation process, it was retitled Deputy Director, IDEC Operations Support, and graded. The post was placed before the job evaluation panel on the 25th of November 2025. The recommendations were approved by the Minister on the 31st January 2026. The post was graded at level 12, and feedback on the outcome was provided on the 5th of March 2026. I attached the confirmation of the job grading marked MS2. The process to create and fill that post was, however, not carried through. When I followed up with the organizational development unit, I was informed that they had been instructed to stop the process on the basis that the post would not exist and that the responsibilities would not lie with it, pending a restructuring. The outcome was not communicated to me at the time. I only learned of it on the 27th of July, 2026.
You say this in the passive voice. You say you were informed that they had been instructed to stop the process. And who had instructed them?
The ID.
Thank you.
You can continue.
The consequence is that the single intake point and the case intake committee were never fully operationalized. In practice, matters continued to be received directly, mainly through the IDEC spokesperson, including by the ID herself and me, and were not always routed through the collective assessment that the manual and the case intake criteria contemplates. It is against this background that I raise a concern of general application and not as a comment on the guilt or innocence of any person. Where a multi-level intake process is bypassed and a matter is received, assessed, and authorized by ID alone, the very protection that the process was designed to provide objectively, auditably, and the insulation of the ID from allegations of targeting falls away. That, in my respectful view, is the significance of the process for the Commission work. I'm aware that the operational manual has been described before the Commission as a draft. I record that the manual was signed by the ID and me and was distributed to staff, to every employee of IDEC as an operational manual. A review of the manual was subsequently undertaken by a single person, which is different from the inclusive consultative process by which the manual was originally made. In my experience in government, a policy of this kind is developed and reviewed through a consultative process and remains applicable until any review is completed. I have not seen the review.
Was there an actual review?
Yes, I've learned that there was the actual review.
Have you seen a document?
I have not seen the document.
How did you get to know that there was a review?
It was discussed in my discussion with the ID. She indicated that she had instructed Advocate Mohammed to do the review. We also had an investigators working session where Advocate Mohammed was in attendance, and she indicated that she was in the process of reviewing the manual.
Is Advocate Mohammed within IDEC or is...
She is within IDEC.
Oh. All right, thank you.
In what position? Sorry.
Except my question, is she a prosecutor? What's her position in IDEC?
Yes, she's a senior state advocate.
Thank you.
Not at the level of a DDPP.
No.
All right, thank you.
As matters stand, you say you haven't seen that reviewed manual, but you know that there is a manual. To your knowledge, as matters stand, what is applicable, even if it's not being applied? Is it this new version, or you still, to your knowledge, at version 2 that's supposed to be applied?
Chair, as a matter of process, as long as the reviewed manual has not been approved, the original manual still stands and remains operational.
You would be one of the approvers by virtue of your position.
I'm not sure with the reviewed one.
Okay. So you're
because
saying,
I was not part of the review.
okay. Now, I'm just trying to understand. You were a signatory to version 2.
Yes.
And I have assumed by virtue of your position as the investigate, you are the head of investigations.
Yes.
So I assume that's why you signed this manual.
That is correct, because it was, as I said, a consultative process, and we would discuss extensively also with the ID and the other colleagues. So after that consultative process, and I presented it to her, we agreed that it's ripe for approval, and then that's why I signed off on it. The review process, as I said, I wasn't part of it, so I cannot say to the commissioners now that I was going to sign or not, because I'm not sure.
Okay. Thank you.
What does the manual say about consequences for failure to follow its processes? Does it say anything at all?
Yes,
So
that-
say, for example, a case comes in, the case assessment report is not there, that CIS process that you mentioned, I hope I'm saying it correctly, if all of those processes are not followed, what does the manual say will be the consequence?
I think the manual does allude to the fact that failure to comply may lead to a disciplinary process.
But the ID can discipline herself, so if she's the one who's flouting the manual, does the investigation continue even if the processes set out in the manual are not followed? That's really what I'm getting at.
Commissioner, obviously, if the ID herself flouts the manual, then the person that she reports to would have the responsibility to take that action,
So that would be the DPP.
the NDPP.
Does the manual say it applies to her or only those below her? Can we just clarify that? Does it apply to everyone at IDEC or only those below the ID,
It applies to everyone,
including the ID?
yes.
Let me ask a related question. Are exceptions provided for? There is exceptions not to follow the process strictly. Are there provisions for exceptions? With
Chair, on the
regard
top
to-
of my head, I can't remember if there were exceptions. But
Can you?
my understanding of
Yes.
the architecture of the NPA Amendment Act is such that the investigating director has got all the powers to decide on anything, including deviating. So, for instance, even with authorization, that she can, Meromutu, decide on an authorization.
Can you please look at the manual during the T adjournment and see if the manual itself does provide for exceptions? I hear you on what you say about the Act. Did you refer to a specific section?
Yes, it's section 28(1), I think.
20.
Yes,
Isn't 28(1) about investigations?
yes, on the authorization that she can, Meromutu,
But I'm not sure that that answers my question about exceptions with regard to the application of the manual.
yes, no, that does not deal with that.
yeah,
Commissioner. I will check the manual as suggested.
All right, please, thank you.
Mr. Sisoko, you said that I think it was in response to Commissioner Kumalo that it would be the NDPP that would have to deal with that matter.
That is correct.
And how would the NDPP know?
Obviously, there should be reports that go to the NDPP.
And the reports would come from the ID?
No. If I understand you well, you mean if there is an issue about non-compliance?
Yes.
Yes, so if there's an issue about non-compliance, it means employees who become aware of the non-compliance, who reports it to the NDPP would have to take action about it.
So essentially, employees would have to report to the NDPP?
Yes.
You know, the natural question that follows is, in these instances, we know there was flouting of this manual, and you were well aware of that.
Yes.
Did you report to the NDPP?
I personally did not report, Chair, but I'm aware that I was informed that there were a number of complaints that were referred to the office of the NDPP, the former NDPP.
I may have misheard you. Did you say that you cannot or you did not report?
No, I did not report.
Is there a reason?
Chair, I don't have a reason why I did not report. I think I say something about it later in my affidavit. I have been through a lot, and when some of these things happen and you hear that, there were reports that were reported to the former NDPP, and there was nothing that happened. I just felt that it won't assist me anyway.
Now it looks like you were part of the problem. 2 of your colleagues came to this commission and they could show us emails that they wrote in 2024, 2025, raising serious concerns. Although nothing was done, it's clear from their emails and their communication that they raised concerns about how things were done. You now have to account to us, and you did not do anything. And because you did not do anything, it looks like you were part of the problem. You were part of the reason why the manual was not followed to the letter.
Chair, I will take responsibility for that, but I had my own personal reasons. The fact of the matter is, these issues, as they were raised, and you would have seen in the emails, the colleagues were sending these emails to the ID herself, and I'm copied in those emails. And in bilateral meetings with the ID, we would discuss these issues. And she would indicate, for instance, his displeasure about the colleagues on how they raise these issues or raising these matters, because she believed that there was nothing wrong in how they were approaching that case. So I left it at that.
You mentioned in your response that you were copied. In some of those emails, they were sent directly to you. And particularly, I know one of the witnesses, Mr. Rapesu, you would have been also his supervisor, because that would have come out in the investigation side of things. So, and you say that in then discussions with the ID, she would raise displeasure about them raising these issues. And in response to that, then nothing is.
Yes,
is done.
and as it relates to Mr. Rapesu's issues that she raised with me, I took them up with Chief Perumal. And in those discussions, Chief Perumal would make it look like there's a difference of opinion in the investigative approaches. So part of what I would want to do is to try and get the team to be coherent. So I tried to sort of mediate whatever conflict they have about a specific issue and how an issue is dealt with. So that's how I approached it.
But I'm sure you could tell that there's a difference between what you call a sort of a difference in approach, or when Chief Perumal says to you, it's more of a difference in approach, that there's a difference between that and blatant disregard of rules, the law. When you are then dealing with those issues and that occurs to you that that's happening, surely there's more to be done than just building coherence in the team.
So, as far as I can recall, the issues that Rapesu raised with me was in relation to the process of the dockets and the issue relating to one specific witness and how that had been approached, and the instruction from Chief Perumal, which he was uncomfortable with, which, as I said, was discussed with them. But not long after that, that is when he was removed from the investigation. That's how I recall it.
It's fine. I think we will, in the sections dealing with your involvement, deal with some of the issues that were raised. And I think the records will show that it's more than just a difference in approach. There was actual disregard of both your internal operations manual and I would say the law as well. We can then move to the next section of your statement, which deals with your involvement in the crime intelligence related investigations. Chair, and characteristic to seek
Let us start.
adjournment, but
Let us start. Were you going to say?
I was going to say, because this is the second half of his statement.
Let's start. Yeah.
No
We
problem.
can stop at 11.
All right. Mr. Soko, then we can move to paragraph 33, where you deal with your involvement in the crime intelligence related matters.
That's correct. Before dealing with the detail, I stated at the outset that I had no direct or substantial involvement with these matters. I was not included in the team, and in the ordinary course was excluded. Sometimes Chief Perumal would mention something to me in passing about a case and how good evidence he had obtained. I think there were a number of meetings where I was invited, which I cannot remember details of. I came to learn of aspects of the matters largely when complaints were reported. Given the position I hold and the leadership role I ordinarily play, the exclusion was unusual and had not previously occurred in my time at IDEC. I was drawn in only in discrete issues. There were, in essence, 4 occasions on which I had involvement. Assisting Mr. Rapesu to obtain the docket, a meeting convened by the ID to discuss the CI investigation and a report to the minister, a conflict between Advocate Ramsamy and Chief Perumal, and the disciplinary and legal matter concerning Mr. Rapesu.
I think it's important to mention which minister. Please reread.
Minister Mkunu. Minister of Police Mkunu.
I just meant of police. You just said
Yes,
minister.
Minister
only.
of Police Mkunu.
Thank you.
You can then deal with the first issue, which is when you were assisting Mr. Rapesu to obtain the dockets.
On or about the 6th December, Friday, I received a call from an IDEC investigator, Mr. Rapesu, who informed me that he had been instructed by Chief Dylan Perumal, to fetch the dockets containing the allegations against the CI officials from the station, and that he had been told the dockets were held by the inspectorate with General Jacobs. Because of the level involved, he asked me to facilitate. I telephoned General Jacobs and told him that the investigators would like to see him in relation to the dockets in his possession. He did not inquire why. He did not seem surprised. It was a very short conversation, and he said that I could come and see him. I think I meant he could come and see him. At the time, I did not know.
He is in Mr. Rapesu.
Rapesu, yes. At the time, I did not know whether the investigation was authorized. I assumed that if an instruction to obtain the docket has been given, the investigation must be authorized. I later learned that when Mr. Rapesu sought to collect the dockets, General Jacobs asked for a letter. Mr. Rapesu reverted to Chief Perumal. The ID wrote the letter. The letter was sent to General Sintumule, and she then dealt with General Jacob, which is how the dockets were ultimately obtained. I was not involved in those later steps, and know of them only from what I was subsequently told.
I think at this point, we may take the adjournment.
Thank you, Chair.
Let's adjourn and resume at 11:30.
Good morning again. It's 29 minutes past. We are ready to resume. Please make sure that your cell phones are on silent. Thank you.
Yes, Ms. Bowe.
Chair, just a small matter of housekeeping. I had earlier asked the attorneys to make copies of a set of screenshots. They should be somewhere in front of you, marked CJC 400.29. They'll be added to the next exhibit file. Essentially, they are screenshots of email correspondence involving the CI matters, and these come from Advocate Ramsamy. They are not on the record. They will form part of her upcoming testimony, but I would like to make reference to the fact of her sending the emails at some point during the testimony, so I just thought to provide everyone with it. But it's not for use now.
When documents are handed to us at hearings, I always make the request that they should be placed where they should be in the files. I noticed, I think yesterday, that some documents are in the pockets, file pockets on the inside covers, and that this is not always done. This is a request I've always directed at our attorneys, the commission's attorneys. So it seems we have not always been assisted in this regard.
Chair, I'll ensure they not have lunch until they've inserted them properly in your files. Before the tea adjournment, commissioners, before we return to the statement, Chair had asked the witness to have regard to the operations manual. Perhaps we can start there.
Please assist Mr. Sissoko.
Thanks, Chair. I think the two issues Chair wanted me to address was the issue of applicability. That issue is addressed in the manual, page 18 of the manual, where it talks to scope and applicability. It reads, the manual is designed to provide comprehensive guidance and standardization within IDEC and encompasses all aspects of the IDEC's function. The manual is intended for use by all personnel working within IDEC, including investigators, prosecutors, support staff, management. It is applicable to all levels of the IDEC. So that is the applicability part of it. However, in relation to consequence for failure, it's not provided for.
And I think I'd also asked a question about whether it provides for exceptions.
Oh, yes. I couldn't find anything relating to exception in the manual.
Thank you, thank you.
Thank you, Chair. Mr. Sissoko, if we can then return to the section that you dealt with before the tea adjournment, and that relates to assisting Mr. Rapesu with the docket. Am I correct to understand that this would have been the first time you learn of the CI matters?
That is correct, Chair. The call I received was already after hours. If I'm not mistaken, it should have been around 6, around there in the evening. And as I said, after the conversation with Investigator Rapesu, I called General Jacobs and facilitated that meeting. And then I gave Mr. Rapiso that feedback. As I said, that only later I've learned what transpired after.
Yes. My interest is in when he tells you he's seeking these dockets, and he's essentially alerting you of this new investigation. This was the first time you're finding out about that investigation?
Yes, it was the first time I found out that there is such an investigation. As I said, that when he said that he got the instruction from Chief Perumal that he must get the dockets, and he's been to a station, the station said, informed him that they are with inspectorate. And that is why he was asking for me to assist for the facilitation. I assumed at the time that it must be authorized, because otherwise why would you go and look for the dockets without an authorization? But I did not have that discussion with him. All what I did was, because he's asking me to facilitate, I just facilitated that. And then, of course, I learned later that there was this matter which has been authorized.
So in this instance, you are now finding out that there is Chief Perumal is issuing instructions related to an investigation you know nothing about.
Yeah.
And then at this time, Chief Perumal was reporting to you. Is
Yes.
that correct? Did you then go to Chief Perumal and say, what is this investigation?
Yes, I think subsequent to that, we would have had a discussion with Chief Perumal. And as usual, with these matters where he says, no, it's a matter that comes from ID's office, we're investigating CI. So that would have been subsequent to my discussion with Mr. Rapiso. In any event, I would have expected that Chief Perumal would brief me about it. But as I said, that it was a test conversation about it to say it's a CI investigation authorized by ID, and there is a team already working on it.
And in this instance, did you then approach the ID to inquire about it?
No, I did not approach the ID to inquire about it.
Thank you. I think then you can move on in your statement.
Okay.
I assume then that you did not see the Section 27 referral.
No, I did not see a section. I had not seen anything in relation to the matter at that point. I did not see anything in relation to the matter. I think the first time I saw anything about it, it would have been in one of the meetings where there was a presentation, if my memory serves me well.
We can then proceed with the second instance of your involvement in these matters. It's the meeting convened by the ID and the report to the Minister of Police. That is paragraph 36 of your statement.
Yes. So approximately a month later, in January 2025, the ID convened a meeting. Which I don't know what I was trying to say.
To
which I was called, yes. She said the meeting was to discuss the CI investigation, and that she was required to report or write something to the Minister of Police, Minister Mkhunu, and to send correspondence to the Chief of Staff, Mr. Cedric Nkabinde. The meeting was short, did not go into detail of the case. When the ID mentioned Mr. Nkabinde, I alerted her to his history. In my assessment, Mr. Nkabinde is a dishonest man, and I explained to her there was evidence, including data analysis by our data analyst in the Blue Lights investigation matter, indicating that Mr. Nkabinde was working with or was colluding with the suspects in the Blue Lives Matter and against that investigation. I advised
Sorry. You use the definite article, the Blue Lives Matter.
Yes.
Which Blue Lives Matter is this?
So the Blue Lives Matter, Chair, it's an investigation that we started whilst we were in IPID. It's on high-level police corruption. The suspects in that, or the accused, because now they're appearing in court on that matter, are generals in the police. General Pahlani, General Ngwenya, it's quite a number of them, and brigadiers and so forth. So that, for me, as I indicate here, it was a concern that she will be.
All I wanted was
Okay.
a reader of the transcript must know what Blue Lives Matter you are talking about.
Okay, Chair.
Thank you.
All right.
Is it called Blue Lives Matter because it relates to the subs general, or it has to do with procurement relating to installation of blue lights?
It has to do with procurement and installation of blue lights for police vehicles.
Thank you.
Mrs. Soko, please just clarify paragraph 36. You say the ID convened a meeting to which you were called. She said the meeting was to discuss the CI investigation, and she was required to report to or write something for the Minister of Police, Minister Mkhunu. That report to the Minister of Police, did it relate to the CI investigation or something else?
To the CI investigation.
And did she tell you why she needed to report to the minister on the CI investigation?
Chair, I think she mentioned, and I'm speaking under correction because it's something that happened a long time ago, but my memory serves me well. It was about the fact that she had received correspondence from the minister about this CI investigation.
Did you see that correspondence?
No, I had not seen it.
Thank you.
And in this instance, when you are called to this meeting, you still didn't know anything about this investigation?
Yeah, in fact, that meeting was really the first time where I got a glimpse of what this is about.
Do you recall the exact date of the meeting?
I think it might have been the 22nd of January, if I'm not mistaken.
When you say you caught a glimpse, you weren't part of the full discussion?
No, it was, I'm saying it was for the first time that I got to hear what is being investigated and who are the targets of investigation or persons of interest.
Okay. And in this instance, is this considered you starting to become part of this team, or what would have been the purpose of your involvement?
Chair, I reckoned it was to be briefed, to get a brief about it, because as I said, I had not known about it before. So I think that was the purpose of being invited to that meeting.
Was this before or after Chief Perumal had told you how good evidence that he had obtained was?
No, it was before.
It was before. All right, thank you.
You can continue. You were at the last sentence.
I
where
advised her to be careful.
Advised her.
Yes. I advised her to be careful and said that I would not advise her to report to or through him, meaning Mr. Nkabinde. The ID asked me to obtain information from the data analyst so that she would have something she could work with, and so that she could advise the minister or the minister's advisor. I did so and provided it to her. The information I obtained from the data analyst is marked MS3. It is a document I provided to her showing Nkabinde's collusion with the accused in our investigation. I understood that there had at one stage been a consideration to charge Mr. Nkabinde, but that this was not done. The DPP at the time, Advocate Low, decided to defer the question of Mr. Nkabinde and focus on the matters involving the police generals and other police officials and service provider, in part out of concern about possible Section 342A of the Criminal Procedure Act application to remove the matter from the court roll. I was informed of these decisions. I was not at the ID at the time when they were taken. My concern is that this matter was not dealt with in the normal way. Ordinarily, even a matter received by the ID herself would be referred to me or one of the DDPP colleagues or the chiefs to evaluate whether it falls within the mandate and to advise her before she takes a decision. Here, the ID received the matter and it appears took the decision on it herself. The operational manual, especially as it relates to case intake, was not fully operationalized. Before the ID's testimony at the ad hoc commission, there were very few Section 27 referrals that came through. If they did come through, they would be received by her office. I specifically recall the speaker matter, where she called a meeting about the matter and instructed that it be considered and appointed a team to deal with it. Whereas with the CI matter, I only learned of them when they were already authorized. They were not discussed with me before they were authorized. I did not see Honorable Adams' Section 27 referral either. Even when Advocate Surunya asked me about it, I informed him that I did not see it. By way of context, on referrals generally, historically, most of our matters flowed from the Zondo Commission, Mpati Commission, and the Nugent Commission, in respect of which the former ID had already granted sweeping authorizations under the presidential proclamation establishing the ID. Attached is the presidential proclamation marked MS4. There was therefore no need for Section 27 referral. As per practice, most matters are referred to the DDPPs, who then prepare a submission to the ID for authorization. Most matters in IDEC space were authorized as a result of the presidential proclamation. The table below illustrates this point. So the table shows that the security cluster and commission matters are 137 in number, which represent 88% of matters that are within IDEC. And the other IDEC mandate, those are the matters that would have come either from other law enforcement agencies or through Section 27 referral. They are 18 in number, representing only 12% of the matters that came to IDEC.
Mr. Sisi.
A matter, sorry, Ms. Paul. We now know that IDEC received a Medicare 24 referral. Where does it fall in your table?
It will fall under the IDEC matters, IDEC mandate matters.
Mr. Sisoko, you say that very few Section 27 referrals from previous witnesses. What we heard was that there was only one other referral prior to this. Is that your recollection? And that would have been the speaker matter. And that the one that comes under Medicare would have been the third.
No, as I said, I'm working from our register. This statistical information comes from the register. As I said, that these IDEC mandate matters, which are 18, would be matters that either come from law enforcement, which they refer to us, or they come as a result of Section 27 referral. The ones that are Section 27 referral that I can think of right away is like your speaker matter, your Project Golden, and which one am I missing now? Yes, the Medicare one.
Does the register delineate with that number of 18 which ones were Section 27 referrals and which ones emanated from other law enforcement agencies?
No, the register will show that these matters are the matters that came after those presidential proclamation matters, which are mainly from the Zondo Commission, the Mpati and Nugent Commission.
So in essence, the 18 is just matters that came after
Yes.
the commission matters?
Yes. So they wouldn't have been authorized in terms of that proclamation.
They would have been authorized in terms of your protocol, well,
Yes.
except for Project Golden and
Yes.
the speaker matter.
Yes, and of course the CI matters.
Excuse me?
And the CI
Oh,
matter.
the CI yes, of course. All right, thank you. You can proceed with paragraph 44.
After the ID gave public testimony at the ad hoc committee, the volume of complaints increased. My own practice on receiving a complaint, whether a Section 27 referral or an email from the spokesperson, Mr. Henry Matumani, is to assess whether it falls within mandate. If it plainly does not, I respond or refer it out if the position is unclear. If the position is unclear, I meet the complainant to establish whether it falls within the mandate. And if it does not, I refer it to the appropriate agency. This would be done by way of a memo to the ID with recommendations. Of the matters I have received, I recommended only one for authorization. Attached MS5 is the register of matters that went through my office or I became aware of. Of the 27 matters that were recorded in the register, 13 of them were received by me. I only recommended one for authorization. Chief Boy received 5 matters and Chief Perumal received 10 matters. At the time when the CI matters were authorized, I was on duty and no one was acting in my position. I went on sick leave on the 10th of November after I was kidnapped. Then Chief Perumal was appointed to act in my position until I returned to work on the 13th of January 2026.
Just to understand, the matters that Chief Boy authorized, when would that have been? My apologies,
Some of them would have been when, I think most of them is when I was on leave, if my memory serves me well. I think the register will be able to indicate, because it indicates when they were received. The MS5 would show when they were received either by me or Chief Perumal or Chief Boy, and what was done with those matters.
All right, thank you.
Can I just ask, what informs the decision whether matters get referred? They don't fall in your mandate, I accept that. If that is the decision, or the determination, but then you get to refer to other law enforcement. What informs referring or not referring matters to IPID? Because IPID deals with police, corruption, and similar. Is there a principal position that matters never go to IPID? And I ask because in the evidence so far about the crime intelligence matters, there are matters where it looks like on the face of it, until a final determination, that this could have been referred to IPID, because from what one understands of IPID's mandate, that particular issue may well have fallen within their mandate. Is there a principled position within IDEC not to refer matters to IPID?
Chair and Commissioners, the decision is based on the assessment. As we discussed before, that when it has to engage the IDEC mandate, it must meet the threshold of complex corruption or commercial and so forth, high profile. So even if it may involve members of the police, but if it meets that threshold, then it engages the IDEC mandate. However, if it does not, that's where then you have to refer the matter to those law enforcement agencies. As you'd see from the register, how I dealt with most of these matters. Some of these complaints, people complain that decisions were taken in the NPA, they were not happy with it. And when I assessed that, I realized that it does not engage our mandate. In fact, they need to do representation or things like that. Or some of the matters, people will say they went to IPID, they're not happy with IPID. I would refer them to the management of IPID, that they be assisted there, or DPCI for that matter. I would refer them to the head of DPCI, exactly to avoid a situation where we take on the matter that are already in the space of other law enforcement agencies.
Let me ask more directly. A case that has been presented before us. You have the General Lushaba loss of laptop story, and the IDEC gets involved in that matter, and it seems that IDEC is investigating and ultimately got him into court, is investigating what happened subsequent to the loss of the laptop, how that was handled. Someone supposed to have lied, a police officer at a police station, according to the evidence that we've had. On the face of it, it would seem to me that it may well have been a typical IPID matter to investigate, and yet it is a matter that IDEC fully investigates and prosecute. Can you explain how, can you answer my question with reference to that kind of question, to those kind of facts, that you have a case that looks like an IPID case and yet IDEC investigated it? What makes it fall within the mandate?
True, Chair, on the face of it, it looks like an IPID mandate matter. But at least from the explanation that I was given, was that there was quite a number of actions that showed corruption on the part of members who were involved in terms of hiding the true nature of what had happened, manipulating the dockets that were opened, and giving gratification to some of the investigators who were supposed to conduct that investigators with a promotion and so forth. That is the explanation that was given in one of those briefings.
If you absent, and I'm really asking because I want to understand whether some of the problems that we have become aware of, are they structural problems of competing jurisdictions, and therefore the one body ends up dealing with matters that they shouldn't. So if you exclude the gratification issue here, you received a complaint. That's how it's, as I understand it. Mr. Adams filed a complaint and said General Lushaba lost his computer and there was a cover-up. That's how I've understood it to be, that there was a cover-up, and the cover-up goes to even his superior, even General Kumalo, even though General Kumalo was not his superior at the time. But the cover-up goes to General Kumalo, but also now someone took an affidavit at a police station and they misrepresented some things. Forget gratification for now. On the facts that I'm putting to you, would you still have said this is an IDEC matter?
If there was no issue of gratification and alleged corruption, it would definitely won't fall within the mandate.
Okay. Thank you.
Mr. Soko, you can continue with your affidavit. We are now dealing with the conflict between Advocate Ramsamy and Chief Perumal, paragraph 46 of your statement.
The conflict, the ID called me into a meeting to help resolve a conflict between Chief Perumal and Advocate Trushanta Ramsamy. As I understood it, the conflict concerned the approach to the case. Advocate Ramsamy, as a prosecutor, had taken a particular legal view with which Chief Perumal did not agree. The meeting was resolved on the basis that the parties should listen to one another, consistent with IDEC prosecutor-led model, and that the prosecutor is ultimately the person who must take the decision on the matter. This is how the issue was resolved. I must, however, indicate that in subsequent meetings where I was called into or brought to my attention, it appeared that these conflicts continued. And Advocate Ramsamy was concerned that as a prosecutor, her views seemed to be overruled by those of Chief Perumal, and that the ID seemed to take more the side of Chief Perumal than her side.
Do you recall how many other meetings related to conflicts between the two took place?
I honestly cannot recall. They were varied. Sometimes Chief Perumal would come to me. Sometimes Advocate Ramsamy would come to me. Would have a discussion with the ID. You know, so they were varied. I think because of that and the fact that Chief Perumal was not happy with Advocate Ramsamy, ultimately she was also removed from the matters.
Did you not supervise Chief Perumal's work? I mean, if there was conflict between him and the lead prosecutor in the matter, because he reported to you, was that not an opportunity to then look at what he has done and supervise him and provide guidance?
Chair, we would have a discussion about these conflicts, as I said. And in the nature of how our project works, and it's also in the manual, that all the discussions in relation to the project must actually happen at the level of the team, so that even when there are these disputes, the matters would be dealt with at the team level. So where you would have opinions of the entire team in terms of how the matter should be progressed, what needs to be done, what not needs to be done. And the deputy responsible for the matter would then take the ultimate decision if there is no amicable solution within the team. In this situation, unfortunately, the lead, instead of the DDPP, was the ID. So she would then take the ultimate decision on how the matter would proceed. So she would then overrule the opinions of junior prosecutors like Advocate Ramsamy to say, this is how I want it to go. You know, I agree with Chief Perumal, or whatever the case may be. So that is how, in this specific matter, it turned out.
So the head of investigations is excluded from all of that. You don't play a part at all.
That decision-making is that of the ID. I would not be included in that decision-making. We can have a discussion, but you ultimately take a decision. This is how it is going to happen, and it would happen that way.
But you did participate sort of in the lead-up to the final decision about what is to happen, i.e. you mediated this meeting, and then you indicated that there were several other meetings where you had to talk to either.
Yes. As I said, that it would sort of be a complaints session, you know. Chief Perumal come to me to complain. Advocate Ramsamy has made a submission that there is no case and all that, and he believes there's a case, you know, those kind of things, you know. So when we discuss these matters and trying to find out where the fault line lies, you know, you have people who've got strong opinions about these matters, you know, and the ID would then take a decision to say, this is how it must be done, and it ultimately will be done that way. So that is why the decision to proceed the way these matters were proceeded with, the decision to enroll, all these decisions were done by the ID.
Thank you. We can then proceed to the next topic, which is the disciplinary and leak matter concerning Mr. Rapesu. That's at paragraph 47 of your affidavit.
Yeah. The last occasion on which I was involved arose when the ID convened a meeting and informed us that she had received a call from Mr. Nkabinde. Mr. Nkabinde alleged that Mr. Rapesu had telephoned him and informed him that IDEC was conducting an investigation against him, and that Mr. Brian Padiachi was the investigator. In other words, Mr. Rapesu had leaked information to Mr. Nkabinde. Present at the meeting were me, Chief Perumal, Mr. Rapesu, and Mr. Rapesu. Mr. Rapesu denied that he had called Mr. Nkabinde, deposed to an affidavit confirming that he never done so, and offered his cell phone and to take a polygraph test to demonstrate his innocence. I was tasked by the ID to refer the matter to our Security Management Services, SMS, to arrange a polygraph. The SMS began the process by referring the request to the State Security Agency, but then reverted to us to say the State Security Agency does not conduct polygraph tests for internal disciplinary matters, and that if IDEC wished to have one conducted, it would have to procure the services itself. That was never achieved, and the matter was left there. Mr. Rapesu continued to ask about progress, and I gave him what I knew through his supervisor. I was later told that he had lodged the grievance about the issue. I subsequently learned that the grievance had been dismissed on the grounds of a time lapse. At the time I was asked to facilitate the polygraph, I received a report from one of our investigators, Mr. Ndombalo, who had been tasked to investigate the alleged leak. The report recorded that Mr. Nkabinde was refusing to provide a sworn statement about the alleged leak. The ID wrote a letter to Mr. Nkabinde calling on him to provide a statement, and if he's not willing, indicate so in writing. Attached is a letter from the ID marked MS6. Mr. Nkabinde responded to the ID letter with the email dated 27 March 2025. The email is attached as MS7. The ID further wrote to the advisor to the minister, Advocate Pikoli, raising frustration about Mr. Nkabinde's failure to provide a statement. The letter is attached as MS8. Mr. Mbalo expressed that Mr. Rapesu would have leaked the information. Alternatively, that Mr. Binang would have done so, allegedly because he learned that I revealed information to Mr. Binang. Attached is the report by Mr. Mbalo marked MS9. On my reading of the report, I was convinced that it insinuated that I'm also a suspect for leaking the information. So when communicating with SMS, I advised them that I was also volunteering to be subjected to polygraph test based on paragraph 4.2 of the findings of the report. Attached is the email dated 25 June 2025 to SMS marked MS10 communicating same. The obvious difficulty with that report is that the allegation was that ID herself received the call from Mr. Nkabinde. There's no indication in the report that a statement was obtained from the ID about the allegations, and to obtain the records of the alleged call to her, nor were the records of Mr. Rapesu, Mr. Binang, or me obtained. I recently learned a further step that I regard as irregular. While I was on sick leave in January 2026, an investigation was authorized within IDEC in terms of Section 2813 of the NPA Act against Mr. Rapesu for leaking information. The authorization was for the contravention of Section 41(6) of the NPA Act. The application memo indicates that it is from Chief Perumal, even though his signature is not in the memo, and it is authorized by the ID. Attached marked MS11 is the application for authorization. This offense is definitely not within the IDEC mandate and should not have been authorized in IDEC. I regard this as odd for 4 reasons. First, Section 41(6) investigation of this kind is not an IDEC mandate. Second, the ID herself received the initial complaint from Mr. Nkabinde. Mr. Nkabinde would appear to be conflicted in authorizing an investigation arising from it.
She's actually the complainant because
Yes.
Mr. Nkabinde is not the complainant.
Yes, yes,
So in a 41(6), the ID is the complainant.
yes, yes. So that's why I'm raising that. Third, Chief Perumal, as a witness in the investigation, cannot apply for authorization. Fourth, so maybe to explain this, when the ID called that meeting, she indicated that when she received the call, she was with Chief Perumal and Chief Investigator Padiachi. So they had that call, or the conversation between her and Nkabinde, which makes them witnesses in this investigation. So that's why I'm saying that Chief Perumal, as a witness in that investigation, cannot apply for the authorization. Fourth,
Had the ID put the call on speaker, or how would they have heard?
yes, that's what she indicated.
All right, thank you.
Fourth, there is no indication that the former IPID officials who are alleged to have attended a meeting with me were approached for their statement. When I returned from leave, Chief Perumal briefed me on the referrals he had dealt with in my absence. So those referrals are those that will be on MS5 that he had dealt with, but he did not mention this one. As I was preparing my affidavit for the commission, I called the IO, Mr. Mbalo, to inquire about this matter. He confirmed that the investigation was authorized and that he was going to recommend that the investigation be closed as there is no evidence to implicate Mr. Rapeso in wrongdoing. I called for the file and established that there is a statement from Mr. Nkabinde dated 27 November 2025. Mr. Nkabinde, who had refused to provide a statement, now deposed to an affidavit which expanded the allegation to implicate me, asserting in substance that on learning of his appointment as Chief of Staff, I had convened a meeting and asked investigators to investigate him and to find anything they could against him. I deny that allegation. Mr. Nkabinde's statement is attached and marked MS-12. What I find odd is that the colleagues who are alleged to have been in a meeting with me are not approached for their statement to corroborate this allegation. I also established that only a subpoena for the cell phone records of Mr. Nkabinde and Rapeso were requested. They were analyzed by Digital Forensic South Africa, and their report confirmed that there is no record of the calls either from Mr. Rapeso's phone or Mr. Nkabinde's phone. No cell phone records were obtained for the ID phone to confirm that the call was indeed made to her.
Thank you. I think we can then move on to the next section. Why I did not impose myself into these matters.
I've been asked why, given my position and the leadership role I ordinarily play, I did not raise concerns at the time or ask to be included in these matters. The answer lies partly in my own history. During my time at IPID, I was involved in serious conflicts. I stood my ground and I paid a heavy price for it. I was suspended in 2015 and subjected to a disciplinary process and criminally charged, which I regarded as unlawful. The charges related to IPID report concerning the rendition of Zimbabwean nationals. In August 2016, I was dismissed in absentia after being found guilty of gross misconduct at a time when I was hospitalized for depression. My request for a postponement had been refused, and I never gave evidence in my own defense. Following the Constitutional Court finding that the suspension of the then Executive Director, Mr. McBride, was unlawful, he was reinstated to his position. I also challenged my dismissal through the Bargaining Council and was reinstated. I was suspended again in March 2020 by an incoming acting head of IPID, and again had approached the Bargaining Council. I was then reinstated. I testified before the Zondo Commission about police corruption and about political interference that I believe lay behind my suspension. These experiences were costly to me, personally and financially, and to my family. I'm 61 years old, near the end of my career. When I found myself excluded from the CI matters, I made a deliberate decision not to force my way in. I took the view that if the ID did not involve me, it was not because he did not want me involved. No, it was because he did not want me involved, and I respected that. There is, in any event, a practice at IDEC that if one is not on a matter, one does not seek to know its details, and there is a related principle of neutrality. I let the matter be, and I did not ask ID why she did not involve me. There was also a further, more recent consideration. On the 7th November 2025, I was kidnapped while driving home. I was assaulted and robbed. My attackers took my state-issued laptop, cell phones, and abandoned me near Rabridge in the early hours of the 8th November. I reported the matter to the police and received medical treatment. While I cannot say with certainty if this event is related to my work, however, there were two distinct occurrences during the robbery that makes me suspicious. First, the kidnappers demanded a firearm. When I told them I did not have one, they assaulted me so much as if they knew I should have one. Second, when they took all the gadgets, laptop, cell phone, tablets, Samsung watch, they asked for PIN numbers and passwords of all these gadgets. However, on the work laptop, they specifically demanded that I write the password on one of the kidnappers' phone, and they took the laptop to a house. They only did this with the laptop. This occurred against a backdrop of public allegations against IDEC and its leadership, and of threats directed at the unit following the CI arrest. That experience had affected how I approach my work and my own safety. In the circumstances, rather than insert myself into these matters from which I had been excluded, I confined myself to assisting on discrete issues on which I was asked to assist, and to advising those members of the team who approached me for guidance. I otherwise left the ID as the head of the unit and my supervisor to deal with these matters as she saw fit. I wish to make one matter clear. I do not say that there was no case to be investigated against CI officials. My concern is not with whether there was a case, but with the manner in which these matters were handled, and in particular with the departure from the established intake and investigation process. Even where there is a case to answer, it must be dealt with in accordance with the process, and where the process is not followed, the integrity of the outcome is placed at risk.
Before you go to the conclusion, did you play any part in IDEC's presentation before the ad hoc committee?
No, I did not, Commissioner.
Because when the former ID went there, she was not going there in an individual capacity. She was going there representing IDEC. So you are head of operations at IDEC. Did you not assist at all with the presentation?
Not at all.
Not at all. And then after the 6 July 2025 media conference by General Mkhwanazi, serious allegations were made against IDEC. I'm sure you are aware of that.
That's correct.
Did you not, as head of operations, look within to see if there's nothing wrong that IDEC did so that you can assist the ID if she needs to account to the nation or to Parliament?
There were meetings and discussions about those revelations by General Mkhwanazi. And in those meetings, they were dismissed as a counter to the investigations that had happened against the CI generals.
And then internally, Advocate Serunye raised two issues. One was the Section 27 referral affidavit was not there. The investigators did not have it. The prosecutors did not have it. So that was the one issue. The second issue was the two CI matters, the Mokwele matter and the Lushaba matter. There were no DDPPs who were leading those investigations. And he raised those issues as serious concerns. And as far as I understand, you were copied in that correspondence. Why did you not do anything? If he says the Section 27 is not there, it has not been provided. And secondly, these investigations were supposed to be led by DDPPs. They were being led by junior advocates at IDEC. Did you not say anything? Did you not intervene? Did you not raise these similar issues with the ID? Did you just let those things slide?
Chair, my recollection is that there were engagements about those issues, and with the ID, and with also Advocate Serunye. And the ID was not even happy about those things being raised, because, as I understood at the time, she felt that these matters were properly within IDEC, and I think she sort of took umbrage why those issues were raised. So in those meetings, I think the issue was, a decision has been taken, matter is authorized, it's going to proceed as she's directed.
And then the last one, in this commission, your investigators, Mr. Padiaki and Mr. Chief Perumal, have been accused of what on the face of it is serious misconduct that may well amount to fraud. The commission has not made findings one way or the other because we must hear all sides. But the allegations are that they created affidavits many months after, and then they backdated the affidavits to create the impression that those affidavits were deposed to on the 6th of January 2025 in relation to Mr. Adams's supplementary affidavits, and then in relation to the Section 21 Section 27 affidavit. The allegation is that the affidavit that has been provided to the commission and the one that we as commissioners have been looking at was only created after October 2025, and it could not have existed in November 2024 when Mr. Adams made the referral to IDEC. Now you as head of operations and head of investigations, when you hear allegations like those, did you make inquiries internally to find out what the position is? And if the commission has been misled and has been provided fraudulent documents?
Chair, my recollection is I heard of these allegations when these matters were ventilated here at the commission. I think Mr. Rapesu would have indicated that he suspects there is something wrong that would have happened with the Section 27. And if I remember his ways was, but the truth will come out. So, I remember speaking with Chief Perumal, if he knows anything about this, and then he says, no, there's nothing like that. Everything, it's on board. And I took his word for it.
Lastly, and it's a question Chair asked, because you are the head of investigations, is it common, is it usual within IDEC that an investigator can start an investigation and conclude the investigation without having seen the Section 27 referral? Because Mr. Padiaki told us that that's what happened in this case. He never saw the Section 27 referral.
Chair, in terms of our processes, and the manual also speaks to that, when a matter is authorized and the project manager convenes a project meeting with all stakeholders, including the DDPP, all information relating to that matter is shared and discussed within the team. It is an anomaly for those documents not to be shared within the team. It is clear that on this matter, there was exception to the rules.
Should it also have formed part of the application for a warrant of arrest, the Section 27 affidavit? So when IDEC applies for a warrant, should the Section 27 have been attached to the affidavit that was placed before the court? How does it work in practice?
In practice, the investigating officer will draft an affidavit, basically outlining the investigation conducted and the offenses that, that are alleged to have been committed.
Sorry to interrupt you. Because the starting point is the Section 27 referral, does he attach it to the affidavit?
No, in practice
he doesn't
it's not.
do that.
In practice it's not.
But it forms part of the docket.
In practice it's not.
So in practice, it does not form part of the docket. You
No,
don't even share it with the accused.
No, it is part of correspondence, internal correspondence, but it's not attached to the docket.
And when they ask for it because they want to challenge IDEC's jurisdiction or IDEC's mandate, how do you deal with that?
Well, when they ask for it, in my experience is that it has been provided when they had asked for it.
So, Mr. Sisoko, when a docket is opened or when an inquiry is opened, doesn't the Section 27 become the A1 statement? And then it can be supplemented if there's anything further to add to the affidavit. How does it work at the start of the investigation? Assume that the investigation has been authorized, either in terms of 28.1 or 28.13, and then a docket or an inquiry is opened. Shouldn't the Section 27 affidavit be the A1 statement?
In practice, Chair and Commissioners, the Section 27 referral is treated differently. When an investigation starts, when it's authorized, then the complainant is approached for an A1 statement, and a full comprehensive A1 statement, which would address all the elements of the offense, is then obtained. And that is what is used as the A1, not the Section 27.
Where does one find that? Is that in the manual or is it your interpretation?
It's the practice.
But where does one find that? Where is it recorded that that's the practice?
I'm not sure if we record it like that in the manual. I must be honest. I'm not sure if we do that. I think the manual states the processes that must be followed, but it does not specifically say what happens in relation to Section 27 or an A1 statement, because it's more of an investigative operational issue that investigators do.
And the reason we are asking this is because Mr. Serunia, Peter Serunia, and Ms. Ramsamy, they have testified in this commission that, and I hope I'm not confusing their evidence and the transcript will bear that out, but they said the Section 27 affidavit becomes the A1 statement, and then any further statement obtained from a witness supplements the Section 27. So the Section 27 is not an internal document. It is the genesis of the investigation. It is the affidavit that must set out what offense is being reported and what offense must be investigated, so that what the investigator looks at and what guides the investigating officer is in fact that affidavit.
Chair, I won't dispute that it may happen in other matters, that, you know, the Section 27 may have been included as an A1, you know. But I'm talking in generality what I know would have happened in most of the matters.
But because IDEC has not had that many Section 27s, you said so yourself, most of your matters are from the commissions, and there was that general authorization from the former ID. Don't you think this is something that should be clarified in the manuals?
Yes, certainly, Chair. I mean, this experience with the commission, it's a lot of lessons learned for us. We already having a discussion internally about IDEC reset and how we improve our operations and including our manual, so that we are all clear in terms of processes, because this process has shown the weaknesses within the organization that really need urgent attention.
And these weaknesses are serious because they can lead to systematic failure.
It is
they
true.
can impact not just IDEC, but other law enforcement agencies, as you have seen with crime intelligence and SAPS.
That is true, Commissioner. Lessons learned.
Thank you.
Can I? Can I just check? You say in paragraph 59 that there is a practice in IDEC that if you are not involved in a matter, you don't seek to know its details, and this relates to the principle of being neutral. But surely that position in practice does not apply to the ID.
Yes, it does. It does not, Commissioner, because she's the ultimate person that takes decision on all these matters. A matter cannot be enrolled without her approving that. So every decision of this nature, it is taken by the ID.
But then by same, well, not same, you are head of investigations. It seems to me you should know what's happening in investigations.
Yes.
So that rule, if it's a rule in the workplace, should not be applying to head of investigations, because you need to be able to speak to the investigations that are happening in your organization.
That is correct, Commissioner. And in most matters, that's what had happened.
Yes.
As I said, this was an exception.
So in a properly working IDEC, a person in your position who is head of investigations is supposed to know and be involved with investigation. When I say involved, I don't mean you run and do the investigations,
Yes.
but you, because you're the overseer
Yes.
of all the investigators and of investigation, so you should know this.
That is correct, Commissioner.
Okay. Therefore, it must mean I'm trying to determine whether it's this a person problem that you ended up in this position where you don't know about investigations that are happening because they're being directed by the ID and who chooses Mr. Perumal, Mr. Pariachi, and others. Is it a problem that a different head of investigation would have been correct to say, I'm head of investigations and I will not be excluded from investigations? Or it's a misunderstanding of your role by both you and the ID that you are also subject to that rule of practice, that you don't need to know what's happening in matters. I think, put simply, is this a structural problem? Is it we happen to have the wrong people in the positions. We had the wrong ID in the form of Ms. Johnson, who did things the way that she did and excluded you, or we had or we had a wrong head of investigations who didn't accept his role and position when he gets excluded. Can you just say which one it is? And the question is important because, at least from where I'm sitting, because among the things that the Commission is required to do is to make recommendations, including recommendations about what improvements, changes need to be done to the organization. So we are going to have to grapple with how did IDEC land where it is today? Is it a structural problem? Is it that whoever employed Ms. Johnson just made a bad decision? Whoever employed Mr. Sissoko made a bad decision? You understand what I'm saying? What I'm asking you. Can you just comment to that?
Chair, the fact of the matter is, in this particular instance, rules were not followed. And I took a decision at that point in time, as I explained in my affidavit, based on my personal history. I take full responsibility that I should have acted differently. But at the time, for me, it was the right decision to take, given the considerations that I've said to the Commission.
I understand, and thank it, It's trying to understand whether, what's behind my question, whether in terms of your contract of employment, which sets out what your job is, you could have asserted to the ID, even if she didn't like it, you could have said, there is no investigation that will happen that I don't know anything about. Does your contract, the terms of your contract, give you that kind of standing, or it's a problem in the contract because maybe she still gets to make decisions finally about investigations? I'm trying to understand that. So I'm trying not to make it personal to you, but to understand what are the limitations other than your personal circumstances. Another head of investigations, will they not find themselves in exactly the same position for different reasons?
Chair and Commissioners.
Perhaps to add to that, besides the contract of employment itself, or in addition to rather, in addition to that contract, there are the annual performance, what do you call them, which you sign with your boss, undertaking that you are going to perform in accordance with, and then, as I understand it, there's itemization of all, of everything that you undertake, you are going to do during that year. Am I correct that there is such a thing? What is it called?
That is correct. The performance agreement.
Yes. Now, I'm adding to what Commissioner Baloyi says, which is a reference to the employment contract itself, and I'm saying there's also this performance agreement. Would what you are required to do not also be, it would obviously be included in that, and would it cover what Commissioner Baloyi is raising, and if it would, what would you be assessed on if not on that? That is what it covers, which includes the issues that Commissioner Baloyi is raising. At the end of the year, how do you get assessed if you've not said, now if you do not allow me to do A, B, C, D, how am I going to be assessed at the end of the year? So basically, that contract would require of you to raise the issues that Commissioner Baloyi is referring to. Now, can you please respond? With all of that in mind, can you please respond to Commissioner Baloyi's question?
Thanks, Chair. My performance agreement provides that I must advise the ID. As I've indicated that these matters were discussed and should take a particular position. I understand the concerns, and in hindsight, maybe I should have taken this issue even further and not let it be as I did. But that's what, to me, at that point in time, seemed right to do. As I said, that maybe I should have acted differently by raising this issue at a higher level, so that what now has been ventilated here could have been stopped. I do, however, I am, however, not sure if it would have made any difference.
Sorry, you may carry on.
No, I was saying that I'm not sure, however, if it would have made any difference.
You say you're not sure because the ID is the person that she was, or what? Because you see, you speak of, you say your contract says you advise the ID. The next question is, well, what does that mean in fact? You advise her on investigations that your people are doing and what they put together as it before she makes a decision, does advising mean that you say to her, on this investigation, there's no case? She ultimately, gets to sign off on the next steps. But what does advising her entail?
Advising the ID, it means advising her on all operational issues. Where matters are under investigation, what are the challenges, what needs to be done. Most of the time, what happens in practice is that decisions like enrollment and so forth would happen when there has been a meeting of all stakeholders to discuss that matter, and when there is a consensus that the matter must be enrolled. But my advisory role is where there are issues of that affect the project, so that we can discuss how we overcome those issues. In relation, for instance, to these specific issues that are raised here at the Commission, there would have been discussions about it to say there are issues that have been raised. There is concerns about these things, and she would give that direction to say, no, I'm satisfied about
case. Has lens at people getting arrested and people getting to court, even people getting arrested and people getting to court. Even before that, it lends at a decision to prosecute. Now, from your answer, it's still not clear to me that things got that bad because the head of investigation was missing in action for reasons that you give, or look at the perimeters of my powers, my position. I can't do more than forget that I didn't tell the ID maybe, but if you look at my contract, I can't do more than just saying, ID, this investigation is poor, the matter is not ready to go to court. In the end, she makes the decision, because if that is the case, it may well be that recommendations or thought must be given to how do you give the head of investigations more power, or ensure that in their contract they get to make determinations about investigations, and they are the ones that sign off to the ID to say, yes, I'm happy with the investigation. And until there is that sign off, the ID may not approve, may not give a decision, or may not sign off. I'm trying to get you, to assist us in answering that kind of question. And I must say that in your answer, the way you've answered, I haven't gotten the kind of assistance that I'm looking for, or the answer to my question.
I understand, Commissioner. The reality of the matter is that this investigation was directed from the ID's office, not from my office. All decisions relating to it were directed from that office, including the takedown. I learned of it after the fact, when in normal circumstances, when you conduct a takedown, we sit in a meeting, discuss how that takedown would look like, whether there's a warrant of arrest to be applied for, or HA 175, all those issues. That was not the case in this specific matter. So it was an unusual situation, and I think that's the best way I can answer you, Commissioner.
would you consider as an appropriate suggestion that I put to you that the system, the structure has to be such that the ID should not be immersed in the investigations, should not be directing investigations, because ultimately her people must satisfy her when she make him her. When they make the decision now, as they're empowered to do, starting with the 2813, right? 2813. The ID should be sitting as a neutral party, so to speak, where others come and persuade her, we need a 2013, and then she can interrogate what they're doing at that point. And then they go and do their work. Now she must authorize an investigation. She should not have been involved in the process of directing, go find this, go find that, because ultimately when they come to her for the, to her in this case, because it was a her, for a 28-1, she must look at it with a fresh eye, with an unbiased eye, if you like. The same for all the various stages that she must authorize. Would you consider it an appropriate suggestion that the ID should in fact be insulated from all of that, so that by the time she's required to exercise the statutory powers of being the ultimate decision maker on the different steps, she looks at things with a new eye and an unaffected eye?
Commissioner, I agree totally. In fact, most of our matters, that's how they have been conducted. She would come at the very tail end. And as I said, that when those meetings happen to discuss where now the team says the matter, the investigation is complete, now we're ready to enroll. And that's how in most matters it would have happened, except for this one.
Maybe the exception suggests that it should be an entrenched position in respect of which no ID has an option to deviate, and there's no exceptional matters, because all matters that come to ID to IDEC must meet the criteria, so they cannot be exceptional and sensitive matters that only the ID should look at.
That is correct, Commissioner, and that's what motivated me to create the case intake criteria.
Okay. Part of the concern you have raised, or an explanation that you have given for not escalating things to the NDPP, you shrugged your shoulders, and we've had evidence as well that where matters have been escalated to the then NDPP, there was no good outcome out of it, and people seem to have ended up in worse positions than they were before they lodged the complaint. How do you suggest to fix for that kind of problem? Is it again a matter of, well, it's about the integrity of the people that you appoint, or it's a problem in